One to Family Law Now After Hours. Today's topic is what if support payments aren't made? When support payments stops or fall behind, the result is financial stress, and there are formal systems to enforce support. In Ontario, the Family Responsibility Office, aka the FRO, collects, distributes, and enforces child support and spousal support orders and agreements. Understanding how the FRO operates and what a default hearing entails will help payees and payors navigate enforcement and resolution. So just some light housekeeping. Please use the question and answer feature to submit your general comments and questions about this topic. For specific questions about the details of your particular family law matter, please contact our team directly. The purpose of this series is to discuss general information on separation, divorce, and family law matters. Any information provided here should not be construed as legal advice. Stay tuned until the end, and we'll be sharing how you can schedule a free initial consultation with one of our lawyers. Now to introduce our speakers today, I am Geneva Spencer, and I earned my law degree from the University of Windsor, where I developed a strong passion for family law, mediation, and litigation. As a three-time winner of the Windsor Law Mediation Competition, I am committed to helping families resolve disputes through empathy, collaboration. I have gained valuable experience working at a non-for-profit legal clinic, supporting vulnerable populations and deepening client-centric approaches. Outside of law, I'm an avid equestrian and a dedicated volunteer with Girl Guides of Canada. I'm excited to be articling with Russell Alexander, and I look forward to applying my skills to support clients through their legal challenges. Also with me today is Lisa Clark. Lisa is a senior law clerk with over 16 years of experience in family law and joined Russell Alexander in June of 2025. Lisa graduated from the law clerk program at Fleming College in 2009 and has developed a well-rounded understanding of the complexities of family breakdowns. She is a member in good standing with the Institute of Law Clerks of Ontario and recently received her designation as an ILCO certified expert in family law. Raised in Kawartha Lakes and now settled in Peterborough, Lisa enjoys photography, reading, online gaming, and spending time with her cats. With nearly 9 years of experience in family law, including 2 years as a family law clerk at Russell Alexander, Sonia Riccelli brings a wealth of expertise to her role. She specializes in various aspects of family law, such as case research, document preparation, court proceedings, and client relations. Recently licensed to practice law in Ontario, Sonia now serves as an associate lawyer at the firm, aiming to leverage her legal knowledge to provide exceptional support to clients. Known for her upbeat and optimistic demeanor, Sonia prioritizes building positive and trustworthy relationships with clients to alleviate the stress associated with domestic issues. And last, but certainly not least, Mark Simpson is an associate lawyer at Russell Alexander and guides clients through family law with solutions that save time and resources. He previously ran his own practice, gaining experience in trials, mediations, and arbitrations, and now serves as a principal to the firm's articling student, me. Mark is a father of three teenage boys. He's a coach certified with up to U13 designation with the Ontario Baseball Association and enjoys mentoring. He has also served on the Hamilton Road Business Improvement Association board. Outside of work, he serves on the Middlesex Law Association and Oak Ridge Optimist Baseball Board and pursues his passion for health and fitness. So to start us off today, we will turn to our first topic, understanding the Family Responsibility Office with Sonia.
Hi, thank you very much. That was great. So I'm going to just briefly touch upon the Family Responsibility Office, and I'm going to refer to it as FRO, F-R-O, and I'm sure the rest of the panelists will do the same because it's just easier to say. So, generally speaking, FRO is a government agency created to help families get support that they're entitled to. So FRO can enforce child support and spousal support payments. And they do this by collecting support directly from the person that has to pay or the payor. Then they keep record of the amounts paid, and then they pay the amount to the person that is receiving their support, so the payee. Okay? So to be clear, FRO will not collect support and pay a payee that support unless they have a court order in their possession to follow. Okay? So, in other words, court orders that deal with support that are made within the Ontario Court of Justice and or the Superior Court of Justice, or domestic contracts dealing with support which are then filed with the court and made into a court order, will then be submitted to the court directly to FRO for enforcement. So the process here is once FRO receives this court order, a file will then be opened with FRO and a package will be sent to the recipient, the support recipient or the payee who is seeking, this package will basically seek further information, specifically banking information. This ensures that FRO will be able to pay directly to the recipient any support payments directly to their bank account. FRO may also send support deduction notice to the payor or the payor's income source, i.e., their employer, who may then be required to pay support directly from their paycheck. So I just want to make a note here that if a support recipient or payee decides that they do not want FRO to be involved in any way, shape, or form, they will need to notify FRO of their intention to withdraw from FRO and enforce the support payment on their own. Either the parties will agree to e-transfer one another, whatever the case may be. So if that's the case, it is important that the payee do speak to a family law lawyer before making any kind of decision like that. And we at Russell Alexander Collaborative Family Lawyers would be able to assist with that. There's also something else I would just like to make mention to, and I know that Mark will touch upon this. So FRO has the ability to enforce support order within every Canadian province and territory. Even if the payor resides outside of Ontario or our jurisdiction, through a reciprocal agreements, FRO can still enforce support order with every USA state and over 30 countries across the globe. They do this by using the Interjurisdictional Support Orders Act and registering the support order here in Ontario, for example. Okay, so it is important that you speak to one of our family law lawyers here at Russell Alexander if you decide to either enforce a domestic contract or support obligation, if you want to change a support obligation that you have, or even start a motion to change, or even if you are thinking of withdrawing from FRO altogether. Our family law lawyers will assist you in the process involved and explain your rights and responsibilities. So this is something that Mark will now touch upon with respect to enforcement.
Did you want to transition, or do you want me to just
Go
state the
ahead.
subtopic?
Go right ahead.
Hi everyone. It's Mark speaking. My topic is how the FRO Family Responsibility Office enforces support orders, and as my colleague Sonia has outlined, the Family Responsibility Office sounds very busy, and it is. And as we know that you want the best for your spouse and your dependents and your family, I would first start off with the guiding principle that FRO-friendly approach is the best way to go. What that means is, as Sonia pointed out, every support order that is issued in the province of Ontario is issued, registered with the Family Responsibility Office. Whether it's withdrawn is entirely up to the payor and the recipient. For FRO, given my subtopic, for FRO to enforce a support order would mean that the payor and Family Responsibility Office need to have communication with each other. There is a wealth of information on the FRO website as to tidbits of really good information on how the payor should go about providing their information to the Family Responsibility Office. But if you do that before, as Sonia pointed out, the FRO has made a case registration number, or before or without the agreement which is being enforced, or the order which is issued, which the FRO is enforcing, they may not have a file for your information to communicate. So for FRO to enforce the support order, it's best to start off with the communication, open and transparent. The payor is communicating with FRO on the front with respect of an agreement or an order in relation to either child support or spousal support. Okay. Next, if the payor has seasonal employment or meets other eligibility criteria, you could set up the FRO to take the money on a monthly pre-authorized debit basis from your account. But there's certain criteria for that. That's available online, and you can speak with FRO about that. If you do not set up those arrangements, or if you are not forth, as this is all for the payor, the relationship is between the payor and FRO. If you are not forthcoming with your payment information, then FRO, as Sonia mentioned, will issue a notice of garnishment to your employer. It might not be the following day that the order is issued, but that only means that if payments aren't being made, the arrears are going to build and build and build. Back to enforcement. With respect to enforcement, after a notice of garnishment has been delivered, you may be getting into the Wages Act, which provides for a net of 50% to be deducted from your pay. That's 50% or 70%. I believe it's 50%. Section 7 of the Wages Act. From there, the FRO, even if your support order is $500, if you haven't been forthcoming with the payments owing to FRO for your dependents, your arrears have mounted to a few grand by that point. If you're, depending on the size of your net wages, they may end up taking a sizable portion on the initial garnishment. Okay. In addition to garnishment, if you fall behind on payments, or maybe other enforcement mechanisms and arrangements that FRO can do that we may get into later on, I believe we are. Other way that FRO can enforce support orders is through sending a notice of garnishment to the Government of Canada, any federal benefits, any tax refunds, things of that nature. They can also spend licenses, they can spend passports, but now we're going on the far end of the other spectrum where we don't really want to be. There's a court order in place. If you're not able to make the payments under the order, you should seek to change it. But ideally, we don't want to delve way into the enforcement mechanisms in the sense of encouraging that. We want to encourage forthrightness with respect to the payor making the payment arrangements with FRO. So again, the FRO needs a case number. The FRO needs money from the support payor. The FRO needs to know where the money is going to be coming from. You can contact the FRO to make payment arrangements with the FRO, whether or not the order is issued. There is a regulation pursuant to the Family Responsibility Support Orders Enforcement Act that allows payors to make direct payments within the first 90 days after the order is issued to allow those payments to go directly to the recipient. That's outside my topic. Addition to that, there is, just bear with me for a moment, please. The only other thing outside of that might need to be mentioned is on that far end of the spectrum, if arrears do build to a great amount, then there could be legal implications or legal action that FRO could take. But again, the FRO is an enforcement body. It's going to be enforcing the support order. And if a payor takes a position with FRO, but it should be changed, the order doesn't reflect my income, you need to take the order back to court to change it. FRO is only enforcing the explicit and express amount stated in the order. Hopefully that helps. Back to you, Jen.
Yeah, that's great. Thanks, Mark. Now, Sonia, can you talk about the steps to take if payment stops?
Yeah, absolutely. So generally speaking, if a payer stops paying support and FRO is actually involved, FRO will just still continue to enforce the original court orders. Will still continue to enforce the original court support order because the payer is still legally obligated to pay support until a new court order or new agreement is made and sent to FRO. Okay, so it is important to remember that if payments stop, the and you're the support recipient, the first thing you would need to do, I think, is at least call a family law lawyer, speak to one of our lawyers here at Russell Alexander, and we're going to be able to assist you on the next steps, because it's, although we're explaining it a certain way, it's actually more complicated to deal with FRO than a lot of people realize. I would recommend that the support recipient would first need to determine if there is, in fact, a support order in place. Okay, so that's important to find out. They can reach out to the court, maybe ask if there is a court order. If the support recipient discovers that there is a court order and FRO is actually involved, maybe they should try contacting FRO to request a statement of arrears, and report the missing payments to FRO. FRO will then be able to take enforcement action. The support recipient can even file a contempt of court motion, or even have the payer brought to court for a default hearing. So these are things that the payee or the support recipient can do. Now, if a support recipient discovers that FRO is not involved, it is likely that the parties were never in court. So I just want to make this clear that if there's any kind of dispute between parties and you are involved in court and there is some kind of support issue on the table, it is a legal requirement that support be enforced by FRO, unless it is, well, I'm not going to go into that yet. Hang on. It is a legal requirement that it be enforced by FRO. So if there's a support, child support or spousal support on the table, and you're negotiating and you're in litigation, so you are in court, and you come to an agreement of whatever it is, there needs to be clauses in that, or in that draft order that is then turned into a court order or final order, that says FRO is involved. Once that's the case, the court will automatically, with a support deduction form and support information form, it's another story, the court will then submit that to FRO to involve FRO. Okay, so if you discover that there is no court order and FRO is not involved, it is likely that you just had a domestic contract and it was never actually registered with FRO. Sorry, it was never actually registered with the court. So this will then, to register this, you will then need to prepare documentation, court documents, send them to FRO. Send them to the court, and then the court will then submit them to FRO. Okay, so that's something to remember. Sorry, I'm all over the place. Guys, am I making sense here?
Oh, yeah.
So it depends on whether or not you have a court order, whether or not you have a domestic contract. Excuse me. So if your support payments do stop, it is highly recommended that you do contact one of our lawyers here at Russell Alexander Collaborative Family Lawyers, because we can assist you with enforcing that support payment with FRO. Okay. To be clear, a payer can stop paying support even if FRO is involved. So it's not recommended by any means that a payer just simply stop paying support through FRO, or stop paying support altogether, because if in fact involved with FRO, FRO can still take legal action. They can still take enforcement action against the payor. Okay, so that's important. And those arrears, like Mark said, will add up. Excuse me. So I'm sure a lot of lawyers have come across instances where the payer will just stop paying and the payee will contact Russell Alexander, speak to a lawyer, and we discover that the reason why the payer has unilaterally stopped paying support is because they filed a motion to change with the court, or they applied to change or end their support obligation altogether. Fortunately, as I just mentioned, excuse me, if the payer does file a motion to change or does try to end their support obligation, FRO will still continue to calculate their support arrears, because unless there is a brand new court order, the payer should not take any action to end support on their own or their own obligations, because FRO will only follow the court order or the new court order. Okay. And yeah, that's for my segment. Thanks.
Awesome. Now, Mark, could you please speak to default hearings? What are they and when do they happen?
Sorry, I was on mute. Of course I can. 2 points to add about the stopping of the support payments is just to flag there is something called an application to discontinue, where the payor and the recipient agree that the support deduction order, which is registered, there is a court order plus a support deduction order, two orders that is filed with the Family Responsibility Office, where the payor and recipient agree for the FRO two-step support enforcement action. They can file an application to discontinue. Another way to stop FRO enforcement is by filing a notice of withdrawal, which can be filed without prejudice of refiling in the future, subject to a $50 administration fee. Default hearings occur when a payor is behind, i.e., in default of the support payments under the court order, the Form 25, presumably could be 25A court order. That means that if there is a court order that provides for the payment of, say, $500 a month as of November 1, 2025, and on the first day of the month thereafter, and you do not make payments until 2027 because you've moved, you didn't get the mail, you weren't aware of how to make the arrangements, you didn't participate in this YouTube session. Could be a number of reasons, but say 2 years down the road, you have not made payments and you are in default. FRO may deliver an application to the payor. The step to take by the payor at that point is to bring a motion to change so that the court will grant flexibility within the default process for the pay, because it would see that the payor is taking steps to address the underlying order. If you don't take steps to address and try to change the underlying order, that is to say, you are content to leave the support order that was made requiring those payments as of November 1, 2025, and you don't challenge the validity or force and effect of that order, then that means that you may owe 2 years of support payments as of the receipt of the materials and the legal action from the Family Responsibility Office. At a default hearing, you would be required to deliver a full, fresh financial statement together with all of your tax returns, probably back to the date of the order for sure, and I would think 3 years predating that order as well. The FRO and the payor can negotiate called a voluntary arrears repayment schedule. Don't tell anybody I shared this, but the rule of thumb is that you can negotiate the payment of arrears over the course, my understanding is 3 years. So if you've got X number of dollars it's owing, and you take that and divide that by 36 months, my understanding is that as long as you've made full financial disclosure, FRO will be content with those proposals. But if they have counsel involved, then that counsel may look at the financial statement, see a brand new vehicle, brand new boat, brand new this, brand new that, and you may not be so lucky. It really depends on the payor's means to be able to pay those arrears. So it all comes down to a lot of discretion working with the Family Responsibility Office at that point. The powers of the court are rather extensive. There's probably about a half a dozen to a dozen things that the court presiding over a default hearing may do, but at the end of the day, the main thing is to encourage compliance with the order. There would be a lawyer assigned from the Family Responsibility Office on the FRO panel that would be working with the payor in those circumstances. And the goal is to get the payments made that over that period of time. This means the payments towards the arrears, not the payments of the ongoing amount. If you make an agreement with FRO to pay those arrears, the expectation, because you had the choice, you can bring a motion to change or you don't have to. But if you don't bring a motion to change, then the expectation is that you pay those ongoing amounts, plus you pay the amount of that you've agreed to pay towards the arrears. If in the event that you do not make those payments, if in the event that you make an agreement to make a portion of the arrears payments, plus you have to pay the ongoing amount as well. You've got the ongoing amount plus the contribution towards the arrears. And if you default in that payment, if you're in the midst of a default hearing, you will be going back to court. And you may be given one or two or possibly three court attendances to get that sorted out. Bring your motion to change, and the court will expect the process of your motion to respect your process of the motion to change if you want to change the order. But in certain circumstances, enough at some point, enough is enough, and you haven't paid. If you are in a default hearing, and I've seen it a handful of times, the FRO council will make submissions, the payor will make submissions, and at some point, in certain circumstances, the judge may say, we're just going to stand this matter down while we get the bailiff or while we get a police officer available, and you will not be leaving to go see your family at that day. You'll be going right to jail. So it's best that you not let things get to that point. That is, make the payments, make the arrangements, make the agreement, and if you say you can't pay, bring the motion to change. The powers that the court has on the motion to change in the default hearing could allow the court to change the underlying order itself. But at the end of the day, it's be friendly with FRO, encourage payment, encourage payment. You've had so many opportunities, you're still not paying. If at that point, and there's still no money being paid on the support payments, then it is the default hearing in some respects is known as the hearing at which payors may be ordered to be incarcerated. If you're incarcerated, the time spent does not make the money that you owe go away. That's a penalty for failing to comply with the order. There is a maximum number of days that you may be incarcerated. I don't recall what it is off the top of my head. And after if you are incarcerated, who knows what's going to happen with your means, employment, and other circumstances, probably makes it just that much more difficult to get the funds in order to make the payments that are required under the support order. In which case, it's just so that is to say, the point being, try to maintain good communications with FRO, open communications, get out in front of all of those terrible, nasty things that might happen at the default hearing, and there is definitely power for a judge sitting on a default hearing to order the payor to be incarcerated. So that's what I have to share about default hearings.
Great, thank you so much. So now I'll speak to the consequences for non-payment of support. So if you think your non-payment will stay between you, the other parent, and the FRO, you're sorely mistaken. The Family Responsibility Office will make it everybody's problem. The FRO has extensive powers and recourse to collect on default payments. These powers are afforded to them under the Family Orders and Agreement Enforcement Act and the Garnishment, Attachment, and Pension Diversion Act. So I'll list off just a few of the ways that the FRO can collect default child support payments from someone in default. Number one, a classic, garnishing someone's bank account. Number two, deducting support from federal government payments. So think of your tax refunds, employment insurance, and Canadian pension plan, and interest on Bank of Canada savings bonds. The FRO can collect up to 50% of your EI and CPP and 100% of savings bond interest. This will also include an administrative fee for every year that the FRO has to instruct the federal government to direct payments to them. Number three, credit bureau reporting. This can take effect 60 days after non-payment and stay on your credit report for up to 6 years. Number four, driver's license suspension. Child support is the right of the child and driving is a privilege. If you default on your child's rights, you lose your privileges. Number five, suspension of your federal licenses. So that includes your passport, that includes a pilot's license. And for anybody who is a seafaring folk, maritime and navigational licenses as well. This one will apply if you have missed three or more payments or the default amount exceeds $3,000. Another one is liens against property. Another one is writ of sale, seizure and sale. So if you own any significant assets, think vehicles, a horse, substantial tool collections, really anything, a sheriff can take that to auction and use the sale proceeds to bring your default payments up to date. Another one is reporting to your professional organization. So this applies to anybody in a regulated profession, so lawyers, doctors, accountants, things like that. And then one that always surprises people is lottery winnings. If you win anything in excess of $1,000, even if that came out of a group lottery pick or a draw, whatever they're called, I don't play the lottery, that can be taken by the FRO to satisfy default payments. So suffice to say, it's bordering on the impossible to escape default payments. The FRO will do what it takes to get the money that is owed. So now to pivot, Lisa, could you walk us through the legal remedies available to payees?
Yeah, absolutely. I think a lot of these have actually already been touched on by everyone. So I'll just kind of summarize, like you've already gone over what FRO can do and how they can collect the money. Um, but basically, for as a support recipient, you want and you make sure that your domestic contract or order is filed with FRO. Um, you can bring a motion to change support is one. I'm so sorry, my notes have just like totally disappeared. Um, but yeah, so the FRO's role is for enforcement only. They're not going to change any support orders or anything for you. So if you want to do that, you'll bring your motion to change, or FRO will do the default hearing. So those are kind of like the legal court remedies that you'll take on top of all of the ones that Jen you described about basically seizing your lottery winnings and liens and suspending your driver's license and passport so you can't do anything fun until you pay your support. And of course, we always recommend that you get legal advice on the steps that you should take, whether it be FRO enforcement proceedings or a motion to change or bringing it back to court.
Right. So now I'll give a talk about the
Can I ask you a
yeah,
question?
go ahead.
Lisa, is if a payor is behind on their child support payments, can the payee withhold parenting time?
No, that's a great question. And no, you cannot withhold parenting time. If no self-help, we do not recommend taking any self-help steps, such as withholding parenting time.
Yeah, no, that just makes the problem worse. All right, so now to talk about how to communicate with FRO. So FRO has an online portal. You can sign up online yourself, or you may get an enrollment letter, which will instruct you on how to register. So on this portal, you can review your case status, see the total outstanding arrears, access forms, things like that. You can also send in questions right to the FRO, print out statements of accounts, and fill out forms. There are also case contacts, and that will be the person that you should reach out to if you have any issues. That's going to be the person who understands and knows your file best, and that's automatically assigned. They have your file, they can answer any questions or deal with issues specifically related to you and your issues. You can also reach out to them, the FRO. They have a contact form on their website. They have a phone number you can call. If you're technology shy, you can send them a letter. They have an office in Oshawa and in Toronto. And the FRO may also contact you. I had a friend in law school, and her second summer job was to call up parents for default payments. So she make the call, get sworn at, hung up on, but that's another way that the FRO can reach out to you. So now, Mark, could you speak to options for modifying or suspending support?
So the most interesting aspect of modifying or changing support is the um, where we have a signed comprehensive full separation agreement, or a full, like, actually, where we have a final court order. And with respect to the final order, you have had a subsequent change of employment, or there's a reason why there may have been a disruption of employment earnings. That would be called an interim variation of a final order. And those are the most challenging. And if you fall into that situation where you have to pay support under a final order, but you have had subsequent interruption of earnings for whatever reason, I definitely encourage you to contact the intake department at Russell Alexander. They're starting off with with a very old line of cases on Brophy and other decisions. It gets into the jurisdiction of a court to change on an interim basis a final order. Definitely something that you should be seeking some consult and some recommendations on that situation. On a more simplified basis, if you are in a position of being able to change on a final basis, a final order or agreement, one, as it relates to changing an agreement, should be very cognizant of the terms and directions in the contract that you've signed. Ideally, you would be aware of all of the terms in the agreement and the contract when you signed it. It should be simply a matter of reading it over again and consulting with, again, legal professionals from our law firm as it relates to the steps that you need to take for the purpose of changing that agreement. But if you have a final order, then you may wish to, again, look at the steps that you need to take in order to bring a motion to change. The legal elements to a child support order are set out in the child support guidelines. I'm trying to remember whether it's section 11 or 13. I believe it's 13. There is the residential arrangements of the children. That means if the support was under Section 3 or Section 9 or Section 8, there is a change of income. All of the elements that went into the initial order, if there's a change on any of those, including the specified table amounts, such as the updated table amounts effective October 1, 2025, that's right. For those listening, there are new tables in force as of October 1, 2025. When you go to address your or change your support order or an agreement in the future, whether it's a year or 2, 3 years down the road, we don't want you to be faced with any surprises. There hasn't been an overwhelming change with respect to the table amount, but it's good to pull the agreement to order out, review it over, and take a look at the support calculation just to see where things fall for you today. If there is evidence that supports a change of the agreement or order, then you may be able to take the steps to change that initial order or agreement, but it's most often going to be the procedural steps that you're going to need to consult about and get some guidance on, if that makes sense. How do you go about changing that initial order agreement? Given that this YouTube is 60 minutes and we don't give specific legal advice and every situation is different, I'm just going to flag it as an issue. It's usually the procedural and process steps that you need to be familiar with in order to suspend or change the support order. If it is a full suspension, you could agree with between the payor and the recipient on a temporary with a period of suspension to allow the payor to get some ground under them to be able to take the steps that they need to take in the process to change the order. I'm really referring to child support, but spousal support would be very similar if you wish to change or vary spousal support. A lot of the similarities and analogous concepts that I'm sharing would apply to that situation as well. So it's what does the original agreement to order say? What is the process and procedure going forward? What is your evidence that you're going to rely to support the requested change? Does the court have jurisdiction? Should you be reaching out or should you not be reaching out to the recipient or vice versa, the payor and the recipient communicating to seek a change? How should you be approaching that? Some legal strategy points that probably would be of much benefit to consult with legal counsel going forward. Thank you, Jen.
Great. Thank you, Mark. Now, Lisa, can you walk us through support for parents struggling to pay?
Yeah, for sure. So if you are a parent and you're struggling to pay your support obligations, there are actually several different avenues that can assist you. So the first one, if it's a court-ordered like variation of support, and your financial circumstances have changed significantly, maybe you lost your job or you just have a reduced income, a family member has become ill and you need to look after them, your separation, lots of different um, ways that your income could be reduced, you can apply to the court to vary the support order, which has been touched on. The court's going to consider, different areas like the current income of both the parents, specifically for child support, the child's needs and best interests, as well as any extraordinary expenses that need to be taken into account. But as a reminder, yeah, never stop paying support unilaterally. Just don't do it. You need to continue to pay what you can and including documents and any attempts to pay so that you can try to avoid arrears and enforcement action against you. FRO also does offer some payment assistance, so they can accept partial payments if full payments can't be made, to try and help stop the arrears from accumulating because there's also interest that gets calculated on the arrears. So you want to try and keep that down as much as possible. You also are going to want to notify FRO of your financial hardship so that they are aware and can help work with you to set up the payment arrangements. And then FRO may also offer payment plans for past due support in some circumstances. There's also, obviously, if your income has reduced, look at any government support programs that are available to you, such as the child benefit, EI, tax credits, deductions, anything that can assist like that. And just some practical tips to help kind of keep you organized, like document your financial situation very carefully. Like it's important that you're really accurate and you have the documentation to support it. Communicate with FRO promptly. Do not wait for them to start chasing you because you don't want that. Um, and just try to avoid any complete non-payment. Pay whatever you can. If it's, you know, a little bit is better than nothing. And then of course seek legal advice early. Do not wait because the longer you wait, the worse it'll get for you.
All right. Now to put it to everybody, where do you get help and advice?
I would start with the Ontario. Hold on, I have it right here. No. Let me scroll down. Sorry. Yeah, OntarioCourt.ca. Simply put, type in FRO, and they'll give you an entire list, process, answer any questions. There's going to be links, summaries, everything we spoke about will likely be there. That's where I would start.
Okay.
You can also reach out, like maybe if you can't afford a lawyer to help you change your support, you can also reach out to legal aid, and they can assist as well. There's some community legal clinics like the Family Law Information Center and those types of things that can offer assistance. And you could also probably do mediation or find a professional that way.
Yeah, that's a good one. Mark, did you want to add anything?
And I had the privilege of mentoring a family legal service provider, and I don't explicitly recall their jurisdiction, but the Law Society had brought in amendments as of, I think, November 2024, allowing paralegals a limited scope of practice in family law. One of the areas I believe was uh, child support, like table amount child support. I think provided the income doesn't exceed $150,000, and I believe that there was some other conditions and criteria in that regard. Um, there was one, Fanshawe College in London was the only institution that had this initial class of paralegals. I had the privilege of mentoring one of those paralegals who is now a family law service provider. And if you're worried of legal rates, not to turn work away from our firm, but to answer the question, if you're worried of legal lawyers' rates, one area that people should become familiar with is the fact that paralegals can now assist members of the public, they're obviously their clients, if you get retained, on straightforward child support matters. But the matter can only involve child support, and I think other very limited circumstances. It can't involve parenting and those sort of things. So the message I want to get to the public is simply that there are now paralegals that can assist on child support issues as well under certain circumstances. I read the bylaws. I read them 8 months ago. I don't recall what they say at this point.
Okay. Well, thank you so much, everyone. Since we have no questions, I'm going to conclude today's presentation. So thank you to everyone for tuning into Family Law Now After Hours. After this session, a brief survey will appear, allowing you to share your comments and suggestions for future topics that you would like us to explore. Your feedback is greatly appreciated. Book now to take advantage of this opportunity for complimentary consultation with one of our lawyers. Please contact our intake team at intake@russellalexander.com and mention our After Hours series to schedule your appointment. Registration is now open for the next event, Do's and Don'ts of Self-Representation. Just go to russellalexander.com/Family Law Now to register. Thank you again to our amazing panelists for sharing their insights today, and thank you for tuning in to Family Law Now After Hours. And that concludes today's presentation. Thanks, everyone.